May please, your lordship.
Yes.
Lord, I pray for listing of matters, my lord.
What is it?
Letter, my lord, it's a PL, my lord, relating to my lord, some road construction acquiring my land, my lord. And matters last week.
What
was-
construction?
My lord, road construction.
Road construction. Okay. Is a new fresh matter or a pending matter?
Case matter, my lord.
All right. Get it listed day after tomorrow.
My lord. Deeply.
May it please, your lord.
Yes.
I pray for listing of a matter, the reservation in promotion matter with the rule was challenged and the division bench has already decided the matter. My appeal has been, the single judge's order has been upheld.
Okay.
But we were concerned about a rule framed by the Assam government nullifying the effect and we were prejudiced. So those series of matters were taken up by a lordship. But because of the presence of Honorable Justice Serichwari,
Yes.
I pray that this matter will, because the urgency is that all seniority we are losing for no fault of
Thursday.
ours.
They will come on first. Yeah.
May please. I beg you, I cannot see, my lord.
3. What happened, Mr. Mehdi?
My lord, in this last occasion, take instruction, my lord, but I have not received instruction, my lord.
These are orders matter. Let them be called out.
And I did-
We are directed to take instruction on that boundary line issue.
Yes, my
The
lord.
hospital matter.
Yes, sir.
Okay. Well, how much time do you need?
My lord, 3 weeks time, my lord.
3 weeks.
Yes, sir.
Mr. Mehdi, Standing Council for Central Government, Mr. Mehdi, submit the 3 weeks time. More time is needed to complete, receive instructions from the concerned authorities in light of the order dated so and so. List of 3 weeks as per it.
Item number 29, my lord, in this case, my lord, as per the order of division bench, my lord, we filed a review petition, my lord.
Hmm.
Review, my lord, it was hard, my lord, the judgment is reserved, my lord,
Hmm.
29. So, my lord, this matter will come after, my lord.
Mr. Mehdi submits that the Union of India has preferred a review. You have preferred a review or have they?
This is not.
Appellant has preferred a review
Yes, my lord.
before the learned single bench and the judgment is reserved. Thus he prays that consideration of this writ appeal may be deferred by 4 weeks.
Yes.
Ordered accordingly.
High level.
May I please lodge. I beg to mention item number 26, madam.
Hmm.
Madam, conducting council D is under abatement, madam.
It is stated that conducting counsel, arguing counsel, Mr. Saraf is in bereavement and thus a request is made to adjourn the matter. Mr. Kale has no objection. Let's list up 4 weeks. How are you, Mr. Kale? Good, fit and fine?
Yes. Much obliged.
Mr. Sarania, the bill has been sent to the governor.
My
Now
2
it's the
years,
call of the governor.
my 2 years.
What, how they are in contempt then?
They could have, my lord, filed rejoinder, my lord. Why the governor has not, my lord, sent?
Governor is not a party before us.
My lord, that, my lord.
Whom will we put the
my lord,
questions to?
Contempt, my lord, direction is given to the.
They have done their part, sir, in the matter of
I'll
compliance.
come by another petition, my lord. Let them, my lord, make another prayer, my lord,
Whom?
by the authority, my lord, the contempt, my lord, to the governor, my lord.
Why should they keep on pleading with the governor that you take action? They have sent it, let the governor take a decision or else you file a fresh writ petition then.
My
That's the only way out.
my lord.
Okay, they acting in compliance of the third learned counsel for the parties, peruse the material on record. A perusal of the affidavit filed by the respondents indicates that they have forwarded a letter dated 21/10/2020 to Honorable the Governor of Assam with the requisite amendments in the rules in terms of the direction given by this court by the order dated so and so, judgment dated 13/7/2018, passed in PIL number 9/2017. Manifestly thus, the respondents have complied with the directions given by this court and no longer can be said to be in contempt. Hence, the contempt case is closed, rule is discharged. Needless to say that for pursuing the legals of non-promulgation of the rules, the petitioners will be at liberty to take recourse of the suitable legal remedy.
there is no matter specific time, my lord. How the governor have to
They
entertain
can't
that,
direct the governor
My-
that you take a decision in so many days.
my lord?
Can they?
No.
And we met the governor, my lord. We met the governor, we pursued.
You have already
take up the
pursued,
matter.
Ms.
Yes,
Leonard, Standing Council, Mr. Shruti has submit that
the delegation of the.
the
autonomous
council is sincerely pursuing the matter with the honorable governor.
My lord.
uh,
And met
for,
the governor also.
uh,
And met the governor also.
and the members also met the governor, but till date, the decision has not.
The governor is required to do aid and advice of the my lord council of
But
minister.
till
That
date,
is
the
also-
decision on
Governor
part of
told us
honorable
like
the
that.
governor is awaited.
My lord,
Discharge. In every matter.
Item number 2.
I tend to move a little fast.
Eight pleases your lordship.
Yes, please. Yes, Mr.
I'm
Manta.
My apologies, my lord, I'm not present in person, my lord.
No, there's no issue at all. We are providing the hybrid mode facility for this reason only.
I'm very grateful, my lord. The
Yes.
petitioner, Mr. Patwari, is also present, my lord.
Yes, all right.
Petitioner
So would you be arguing or the petitioner himself would be arguing?
I'll state the facts in brief, my lord, what had transpired in the matter. My lord, so
Yes.
matter essentially pertains to the disciplinary proceeding, whereby the petitioner was reduced in rank from the senior meter reader to meter reader. Thereafter, eventually, he was again promoted back to meter reader, my lords. The sole charge was that the petitioner used to check meters of customers without authority and impersonating as the inspector of AACB and a person from the Vigilance Cell Revenue Department. My lord, pursuant to the imposition of the penalty, a writ petition was filed, which was dismissed.
Yes. Yes, please.
Which was dismissed on the ground that there were no procedural irregularity and the misconduct has been proved.
Yes.
Thereafter, an appeal was filed, my lords, writ appeal, which was disposed of by this honorable court on 4/6/2012,
Yes.
wherein the order of the learned single judge was upheld.
Yes, please.
Paragraph 6 and 7, they give the reasoning for.
And the review has been filed in the year 2000.
Review has been filed
21.
in the year 2021.
For 9 years.
2839 days, my lords. However, although, my lords, with all due respect, there are no reasons stated in the review petition why the delay has occasioned. But nonetheless, since filing of a condonation is not required, the delay was.
So you can take liberty of filing, approaching this court even after 20 years. What stops you?
Yes, my lord,
Since no limitation is provided, sky is the limit, right?
exactly, but there should have been some pleadings in the review petition explaining the delay.
All right, sir. Let us know what is the scope of a review.
Yes, my lord.
Yes.
Well, here the grounds taken by the petitioner, that essential witnesses were not witness of essential persons were not adduced, my lord. Look, he claims, my lord, that he acted on the instructions of the additional chief engineer, whose witness was not taken during the inquiry.
Whose witness, sir? Did the petitioner file any application for summoning the additional chief engineer, sir?
That was
Authorities did not require his evidence. It is your client or the petitioner who submits that the additional chief engineer should have been summoned as a witness. The authority didn't think that the evidence of the additional chief engineer was required.
And the second ground, my lords, the petitioner claims, my lord, since he was inspecting meters, that was a statutory duty and it could not have been construed to be a misconduct.
All right, very well.
That is his ground, my lords. And one thing, if I may kindly point out, my lords, otherwise during the career of the petitioner.
That is not relevant, gentlemen.
Not relevant.
In this particular proceeding, his misconduct has been proved. That is more than enough.
If my petitioner friend wants to.
Yes, please.
Rahul.
Honorable, therefore appeared an petitioner in person with a review application on 11 August 2021.
Yes.
and and give me a last opportunity to explain my all grievance before the honorable court for my natural and justice.
আপুনি 9 বছৰৰ পিছত আহিছে যে
মোৰ মানে মা ঢুকালে আৰু মোৰ ডাঙৰ ছোৱালী এজনে ঢুকালে ঢুকাৰ পাছত মই অলৰেডি তাৰমানে ইয়াতে কেছ কৰিছিলো
হ'ব হৈছে হৈছে এতিয়া আপোনাৰ এডিচনেল চিফ ইঞ্জিনিয়াৰ সাক্ষীটো নিদি পেলাই
মুকিবুৰ ৰহমান ছাৰ আছিলে মুকিবুৰ ৰহমান এক্সিকিউটিভ ইঞ্জিনিয়াৰ হেডকোৱাৰ্টাৰ ভিজিলেশ্যন আছিলে এই এডিচনেল চিফে যেতিয়া মোক কথাটো কৈছিলে তেতিয়া তেখেতেও নিজে শুনিছে আৰু সেই কথাটো মই চিফ ইঞ্জিনিয়াৰ মোক যেতিয়া মাতিছিলে তেতিয়া মই চিফ ইঞ্জিনিয়াৰ কৈছিলো
সাক্ষী নিদিলে যে
নহয় তেওঁ সাক্ষী মাৰিলে মাতিব চিফ ইঞ্জিনিয়াৰে মইতো আৰু সাক্ষী মাতিলে মোক
Yes.
আৰু মই সেই সংক্ৰান্তত মই কেছ কৰিছিলো WPC কেছ নাম্বাৰ WPC 4598/2003 number 2 WA 16/2012 number 3 WPC 1172/2018 number 4 WPC 7561/2018 number 5 WPC 1338/2020 number 6 WPC 825/2021 and the IA civil 1708/2021 and next review petition আজিৰ যিটো 131/2022 fixed with WA 16/2012 D/O এতিয়া তাৰমানে মোৰ হল উইটনেছ আছিলে এটা বুধিন বৰুৱা এডিচনেল চিফ ইঞ্জিনিয়াৰ আছিলে আৰু সেক্ৰেটাৰী সোনি এপইণ্টমেণ্ট আছিলে অথৰিটি আৰু শ্ৰীমতী সৰোজ দেৱী হৰলালকা আৰু কনজিউমাৰ প্ৰিমিসেছ অফ ফাঁচী বজাৰ
ইংলিছত কৈ দিয়ক
ফাঁচী বজাৰ এইকেইটাত মানে সাক্ষীক তেওঁলোকে নামাতিলে মই যেতিয়া মোক যেতিয়া ডিপাৰ্টমেণ্টে সাক্ষীটো ললে তেতিয়া মোক মোৰ আগত তেওঁলোকক নামাতিলে এতিয়া তেওঁলোকে ধৰক চিঠি এখন দিছে চিঠিখন তেওঁৱে লিখিছে নে বেলেগে লিখিছে মইতো নাজানো গতিকে আমাৰ ডিপাৰ্টমেণ্টৰ ইনকুৱাৰী অফিচাৰে মাতিব লাগিছিল তেওঁলোকক
He submitted, my lord, that important witnesses were not called for, and he claims that the inquiry officer should
You
have.
understand Hindi? Hindi समझ में आती है आपको?
That Hindi बुझी पाए नहीं।
बताइए आपने क्यों नहीं दरखास्त लगाई गवाह बुलाने की? आपने दरखास्त लगाया गवाह को बुलाने का?
चेयरमैन को दिया था एसीबी
कहाँ है बताइए, आपकी अपील में पढ़िए कि मैंने ये गवाह तलब करवाना है मुझको, गवाह बुलाना है, ये बताइए। अपील किया ना आपने, तो अपील में बताइए कहाँ लिखा है कि ये गवाह बुलाने के लिए हमने प्रार्थना किया था।
ऑनरेबल चेयरमैन एसीबी और 13 अगस्त 2019।
अरे अपील जब किया ना, ये तो अभी की बात कर रहे हो, तब आपने जब आपके खिलाफ कार्रवाई हुआ था, जब आपके खिलाफ कार्रवाई हुआ था ना, तब आपने डिपार्टमेंटल प्रोसीडिंग में डीपी में डिड यू मेक अ रिक्वेस्ट कि इनको गवाह इन विटनेसेस को बुलाइए? कहाँ है आपकी रिक्वेस्ट? हो
Request was not made, but he.
So then chapter close, Mr. Manta.
My lord, my lord.
Whether we are supposed to
lord.
entertain this review petition as a civil suit or what?
Chief Engineer copy 17 April 2003.
Yes, read page number.
Question number 4. Mukibur Rahman.
Page number 49, my lord.
Yes, 49. Read, what does it say? Sir, we are asking him to tell your client whether he made any averment in any of his written submissions, appeal, memo, that these witnesses should be summoned. Any prayer?
49 numbers माने application हम दिया था।
पढ़िए, एडिशनल चीफ इंजीनियर को बुलाना है, हमको कहाँ लिखा है आपने? All right.
एडिशनल सीट को हम एक तो चिट्ठी लिखा था 6/9/2001
My lord, no request was made, but that was alleged in his written statement that he acted on the instructions.
That doesn't make any difference. Anyhow,
Yeah.
और कुछ कहना है आपको? और कुछ बोलना है? 9 साल बाद क्यों लगाया रिव्यू?
9 বছৰৰ পিছত মই মানে সেই মোৰ আচলতে তাৰমানে মা ঢুকালে মোৰ ডাঙৰ ছোৱালীজনী ঢুকালে বসন্ত হয় তাৰপাছত মোৰ মানে এডভকেট আছিলে বুধেন শৰ্মা তেখেত ছাৰ মানে মাৰা গ'ল কৰিলে তাৰপাছত মোৰ এডভকেট আছিলে বুজৰ বুঢ়া ছাৰ তেখেত হাইকোৰ্টৰ জাজ হ'ল
Okay, very well. Yes. What do you say, Mr.?
No, this is nothing but an appeal in disguise, my lords. The issue with regard to whether or not evidences were, my lords, properly appreciated or whether or not the witnesses were called for, my lords. That is, my lords, clearly reflected, my lords. There is a discussion along those lines at page 73, my lords, which is the order of the learned single judge.
Single judge, yes.
Yes, my lords. Page 73, my lords, second last paragraph. As regard the purported procedural irregularity in the inquiry proceeding, the petitioner has made some vague and general statements to the effect that he was not provided with defense assistance to
There was
defend himself.
no such submission
No such submission, my lords. Thereafter,
before the single bench. Yes.
Page 74, my lords, it continues, my lords.
Yeah.
Nothing has been brought on record to show that taking the plea of non-availability of the defense assistant, petitioner had raised any grievance in the inquiry proceedings. If he wanted to engage any defense, so he could have very well asked for the same. However, he participated in the inquiry proceedings and availed of all reasonable opportunity provided to him.
All right. So we're dismissing it right now. Dictate the order in chamber or you can do it right now. You want to dictate the order now? All right. Dismissed. Thank you.
Deeply
Deeply
related.
deeply.
Item number 4.
Please, your lordship. My lord, in this writ appeal, my lord, we have challenged the final order, which is at page 42, my lord, at the honorable single judge, my lord. This is regarding settlement of fishery, my lord.
Settlement.
Settlement of fishery.
Respondent number 4 has not been served, madam. Service has not been, as per the report of the Lavazame court, service could not be effected on the respondent number 4. Thus, counsel for the appellant to take fresh steps within 7 days, whereafter process be issued to such respondent. Do you want Dasti?
Yes, my lord.
Dasti service is permitted. Rule is made returnable in 6 weeks.
Right.
Item number 5.
This matter has to come before that green bench matter. It pertains to an allegation is that there's a pollution of river.
List before the environment bench.
Date may be given.
Special bench constituted to hear environmental matters relating to environmental issues.
Publication.
Kindly
Green
date may
bench
be
कर
given.
दीजिए, green bench कर दीजिए. List before the green bench. That's it.
Publication.
Item number 6.
Response numbers 4 and 5 not served.
Not served, Your Lord.
Service has not been effected on the response numbers 4 and 5. Steps for service be taken in 3 days, whereafter process be again issued to such respondents. Do you want Dasti? Dasti service is permitted. Rule is made returnable in 6 weeks thereafter.
Item number 7.
Yes.
My lord, my lordship was pleased to issue notice in the condemnation.
Maybe it's all right.
Well-
Now we realize that even the issuance of notice was not required. It's purely a private dispute. Our writ petition is maintainable.
My lord,
And if writ petition is not maintainable, why the appeal is maintainable? Satisfy us.
my
That
lord.
is the query we have posed on the last date.
Yes, my lord. My lord, the issue is that, my lord, whether the such type of finance company, my lord,
Yes.
can use the muscle man.
All right,
the-
that is now law settled by the Supreme Court.
Yes,
If,
yes,
if there is any Violation, go to the civil suit, file a suit for damages.
No, my lord.
Pay a writ lies.
My lord, our grievance is there. My lord, they have sent the muscleman to take over possession of
So
the
file,
vehicle.
file a criminal case, file a complaint.
We have.
It's all right.
We have lost.
Those are the remedies available. How a writ lies, sir?
My lord, the remedies as per the Supreme Court judgment, my lord.
Yes,
which has
please.
been, my lord, we have relied before the learned single judge.
Hmm.
As well as, my lord, we have annexed the copy of the said order in the appeal memo also, my lord.
Yes.
If my lord may be pleased to peruse,
Appeal memo,
my
file
lord,
memo.
the honorable apex court in the ICICI bank, my lordship is well aware, my lord, that there is a detailed guideline
Hmm.
had been framed that and the.
All right, so there is any violation, the remedy can't be writ court, sir. The remedy is before the appropriate court, damages, criminal complaint, whatever you want to file,
My
prosecution.
lord, we have lost the.
So all
FIR,
right, you prosecute that.
we have lost the FIR, but my lord, till date, they are harassing us, my lord.
Oh,
Till date,
Harassing
they are
us, file a
harassing
civil
us
suit, get an injunction.
And the police is also, my lord, not
Oh.
cooperating, my lord.
That's
And
right.
the
That's right.
guideline which has been, my lord, framed by the apex court, my lord, has
Hmm.
also been blatantly violated, my lord.
Yes, so
My
file a
lord,
contempt then.
my lord, this is the order.
These are in addition to the fact that the writ petition is not maintainable, these are disputed questions of facts. You say that we have paid the installments. They say you have not paid it.
No, my lord,
There is,
it is on record, my lord. We have relied on the record that which we have, my lord.
who is to
deposited
verify
in
those
installment.
records, sir? Who is to verify those records?
My lord, it is
Much
the-
water has flown after ICICI Bank. There are other judgments of Supreme Court,
My lord.
not maintainable, dismissed.
Obliged, my lord.
We had inadvertently issued notices. But the last date we posed a query.
Item number 8 and 9.
Yes.
My lord, the state have filed an IA where they, my lord, they were seeking some leave. But my humble submission is, my lord, the same amount of time would be required. Better lordship dispose of my writ in a very short point, my lord.
The irregularly selected candidates claim seniority on the basis of the candidates selected under 3F vis-a-vis the regularly selected candidate.
No, my lord. I was initially 3F, subsequently I participated in the selection process
Mhm.
and I was selected along with the regularly selected
So
candidate.
what would
And my
be,
number is 7.
what would be your date of entry into service? Would that be 3F or regular
No,
selection?
regular service,
Okay. Mhm.
regular service. I'm
All right, then,
what
what is, who has filed the IA?
IA has been filed by the state, my lord.
What is the prayer in the IA?
They basically want to say that they would like to promote somebody, my lord.
Some of these.
Yes, yes.
Yes.
Page 11, my lord, prayer portion.
You have argued the writ appeal, madam,
Yes,
My lord, my lord,
yes.
today.
lordship,
Now let's start.
my lord.
Yes.
My lord will kindly come to the writ appeal, my lord.
Yes. Writ appeal.
257.
Everybody is ready for final disposal of the writ appeal, please. Now, now, once the matter starts, then don't take those excuses.
I am one of the respondent number 7.
I think my learned friend, Mr. Chaudhary, has some problem. He has undergone a minor surgery, my lord.
Okay.
Can lordship can have it following next, not tomorrow, following Tuesday, my lord.
All right. Then counsel for the parties submit that rather than indulging in the exercise of extensive consideration of on merits in this interlocutory application, the writ appeal itself may be heard and finally decided in this the matter list on
8th, my lord.
8th.
My lord, can I be on 10?
Okay,
Yes, my lord.
okay.
My lord.
As per
No
your
problem.
list on 10th.
I'm deeply obliged, my lord.
Item number 10 and 11.
In this case, I have filed Okalatnama on behalf of respondent number 1 today, my lord. So I may be given a copy of the writ appeal, my lord, taken up day after tomorrow, my lord.
Then senior counsel, Mr. Your good name, please.
S. Mukhtar, my lord. S. Mukhtar.
S. Gupta.
Mukhtar, M-U-K-T-A.
As so and so as put in appearance on behalf of the respondent number 1.
1, my lord.
The service is complete. List on for admission on.
My lord can have it day after tomorrow, if not otherwise.
And what about the writ appeal 107?
107, my lord,
Disconnected.
connected.
It's already there.
It's
Yes,
already, it's already
Procedural.
admitted, and that he was in the final hearing list, my lord, because this was filed, so it came up together. My lord can have it on Friday, if not otherwise inconvenient, my lord. Thursday or Friday, whenever it's possible.
Friday.
Tuesday, list on 8th August,
Much obliged.
along with rate appeal number 107, public 23.
Item number 12.
Wait, similar opinions are pending, Lordship, where direction is given this state correspondent to file counter, Lordship. The petition.
The provincialization matters.
Yes, Lordship.
Issue notice list
Along with Lordship, WBC number.
along the list before the special bench constituted to hear provincialization matters
Lordship,
along
here,
with
Lordship,
students.
under the 2000 Provincialization Act of 2017, we have challenged the particular section of 8.
So
and 8.
validity of the act is under challenge. Some of the provisions, we have sent similar matters to the provincialization bench. Let them take a decision.
But this provision is relates to the salary, Lordship.
To the
This section 8.3 and 8.4 relates to the salary of the tutor. Lordship.
salary.
Yes,
Okay.
but here,
All
Lordship,
right, issue notice connect
Yes.
with students.
collected petition is 1637
Uh,
of 2023.
Copies of the, sufficient copies of the writ petition be served on the learned standing counsel representing the respondents. Uh, Affidavit on behalf of the respondents may be filed within next 6 weeks, list after 6 weeks.
Diploma.
Item number 13.
This time to file my affidavit. I have received my instruction, Your Lord,
You appear on behalf of
for the corporation department.
Corporation Department. What about the private respondents? No one is turning up.
I'm appellant.
You are for the appellant, we know. All right, counsel, Mr. Your good name, please.
G. Bodley, Your Lord.
J. Bodley appearing for the, you already appeared on the last date.
Yes, Your Lord.
Standing counsel, Corporation Department. Cooperative or corporation?
Corporation, Your Lord.
Corporation. Praise for and is granted 10 days time to complete his instructions. This of 10 days.
Item number 14.
My lord, in the last occasion, my lord, the common advocate, my additional advocate was directed to obtain instruction and file affidavit.
What happened, Mr. Goswami?
Instructions have come till now, my lord.
You have received instructions,
Not yet, my lord.
not yet.
Not yet, my lord. In fact, the government had taken the decision at page 215, my lord, which was notified, and that is under challenge.
Hmm.
The matter relates to grant of PRC to some communities from Assam settled in Arunachal.
So you want to file affidavit or not?
Man, we have been writing, my lord.
Arunachal things move at a different pace, we feel. Is it right, Mr. Goswami?
Because this 4th March 2019 decision itself.
This is a
has come,
repetition of 2022,
My lord,
and we are still awaiting your response.
your lordship will kindly grant me some time. my lord. I'll make an effort. Some more time, I'll make it.
Mr. Goswami, additional good general, Mr. Goswami submits that he has still not received instructions from the concerned officials and seeks further opportunity of 6 weeks. We may observe that this writ petition is pending for receiving response of the respondents, being the components of the Arunachal Pradesh state government since the last 1 year. In the interest of justice, one more opportunity is granted to Mr. Goswami for doing the next list after 6 weeks. In case the affidavit is not filed by the next date, this court shall be compelled to summon the officials concerned in this court. Convey this order,
My lord.
they'll wake up.
Item number 15.
May I please, your lordship?
Yes, Ms. Bhagan.
My lord, as far as the last order of 2/6/2023, The respondents were supposed to file their detailed affidavits.
Yes.
Is my lord
Do
till
you
now?
propose to file a detailed affidavit?
My lord, my lord, sometimes may be granted, my lord, will constitute a committee for verification of the patas, my lord, so it takes
Okay.
time. And 4 weeks time may
My
be
lord-
granted.
My lord, if your
Yes.
lordship permits me, I would like to put two things for your kind consideration. Perhaps it
You
will help
already
my.
have a protection, Mr. Burgoyne, you already have a protection.
My
Let
lord.
them come out with a response, then why spend your breath 2 times? Mr.
My lord.
Standing Officer Mr. J. Chutia submits that some more time is required to file a detailed affidavit on behalf of the respondents, because this exercise would require extensive examination of the documents relied upon by the petitioners.
My lord, interim order to continue.
Interim order shall continue till disposal of the writ petition.
Can I take one little liberty? Item number, my lord, 8 and 9, lordship was pleased to fix on 10. Some difficulty, could it be on 17, my learned friend agrees, my lord? 17.
Highly obliged, sir. Highly obliged.
Okay. Re-notify after 6 weeks. 15, item number 15, 6 weeks.
Item number 16.
नहीं, ठीक है, चलो.
The medical student matter, my lord, your lordship has recorded that he did not attend and there is no sufficient medical documents in
Yes.
support of his illness. My lord, I would like to, my lord, I could not make the affidavit. The boy has given me a note. And also, my lord, the documents in support of his attending the class and some medical certificates. This we could not put because they did not question this in the writ petition. May I just point out his practical books and his note he has given to me, my lord. I think it is irrelevant, my lord. I can make an affidavit or otherwise your lordship, I may pray, my lord. Your lordship may refer the matter to the board for consideration. MRI certificate and all these X-ray reports are with the board only.
Why should we undertake this exercise in a writ
So
proceeding,
let board
sir?
decide whether he was unable to attend the class or not.
Well, assuming that he was unable, then what right does he get to hold on to a seat
Not
without
only it.
ever appearing for registration?
That is not correct because what they said that hold on a seat, my lord, when a person, my lord, fails or when a person is unable to attend classes for few years or for few months, my lord, he is allowed to, my lord, continue in the post. 2012, my lord, he was allowed. Then thereafter, my
Where
lord,
is the registration number in the
there
college?
is no restriction, my lord, that's it.
Where is the registration number in the college? You said that you were allowed to even attend the classes. So there must be a registration number,
Registration number is
enrollment
there.
number. What you call it, an enrollment number or registration number?
It is there, my lord.
Well, let us see.
Admission, my lord, there is no doubt, my lord, he took admission and
He
attended
was
classes.
selected. He was selected.
Yes, my lord.
But whether he ever joined,
Yes, yes.
well, let us see. Let us see.
14.
Mr. Das,
Yes,
there has to be an enrollment number or
Yes,
where is that?
yes, yes.
Because every college gives an enrollment number to the student. Let us see.
Identity card is there, my lord.
Enrollment number.
I'll point out that, my lord.
Yes. ये देना वापस.
Page 37, your lordship will say, see.
I know whatever you want to, if you want to give any response to the previous order, file an affidavit.
I'll pay.
Mr. Das praised for
Yes.
and is granted further opportunity of further opportunity of 2 weeks to responding to the observations made by this court on the last date, that is 26/7/2023. List after 2 weeks.
After 2 weeks.
ये नोट भी लौटा था.
लो.
Item number 17 to 19.
Lordship, Mr. B. Gogoi appears, my lord, he's on legs, my lord, lordship, the matter may be passed over.
Pass over.
Item number 2224.
There is one writ appeal of 2017, the others of 14.
Yes.
Why this split over kind of litigation? Spread over a period of,
My lord, I will be arguing a writ appeal number 346 of 2017.
346.
Common judgment, my lord. Common judgment.
Common judgment. You will be arguing 346. And who are for the others? Are the councils available in item because they are all connected? Writ
Yes.
appeal number 72, 344, 345.
আমি দুটাৰ কাৰণে আছো।
We can't.
Well, I'm appearing in item number 23 and
Sorry,
24.
we are all set to hear the matters, but the councils in the connected matters have to be here. We can't go on a hair splitting exercise. Separately, to
I think in item number 22, the petitioner expired, my lord. I think there was a notice sent by this honorable court also.
22, then a file.
22.
In item.
Because
I'm
The-
otherwise ready, my lord.
we are also, the list is almost complete.
Yes.
But they are, unless the other councils come.
In item 20, Chaudhary appears. Oh, he's there. My lord. He's there.
We directed on 28th March, let the writ appeal and be notified. Whether notice has gone,
I think it has gone, my lord.
let's check. Communicated to this so and so. 28/4. What has happened thereafter? So then we'll abate this matter, what else? This matter will abate, there no one is coming forward.
Yes.
We have already informed. Let's abate this file then. The proprietor of the firm, writ appeal number 345/14 has passed away. Intimation was sent by this court in pursuance to the firm in pursuance of the order dated 28/3/2023, but nobody appears on behalf of the appellant, hence the appeal abates and is disposed of as such. All right, this is item number 340. Writ appeal number 345.
344 the council cannot pay them.
Okay. What about 72/17? Mr. H.R.A. Chaudhary, Mr. S.K.
Yes.
You are appearing. What about writ appeal number 344? Mr. Nilay Datta used to represent. And S.V. Bhuyan, the associate counsel should be there.
Exactly.
Senior advocate, otherwise also name should not be mentioned. This practice is continuing there. Therefore, we are tolerating it, Mr. Chaudhary. Otherwise, senior's name is not supposed to appear in the call list. There is no purpose of designation then. You are not tied to a brief.
Correct.
What to do? 21, then
Or we can
23,
do one thing, my lord, we can.
Mr. S.S. Day,
My lord, senior is appearing.
you are appearing.
I'm appearing in my lord 346 and
345.
345.
365 also,
Yes.
Rana Construction.
365 also, yes.
Okay, so in a larger number, you are appearing only one matter remains
Yes.
unrepresented,
Yes.
SD Enterprise. What should we do then?
Or we can inform them, my lord.
If
Also we'll
possible,
have a-
please inform Mr. S.B. Bhuyan or
Yes, yes.
any of these persons,
Yes.
any of these lawyers. Should we pass it over?
Yes.
Should we pass it over for the timing or
Or
what?
also we'll have it on some other day, my lord. We'll inform them, my lord.
No one has appeared to represent the appellant in Writ appeal number 344 of 2014. What's your associate's name? Mdas. Mr. Learned Counsel, Mr. Mdas assures that he will inform. You're there. Your name is there.
That may be someone, I'm not sure, Lordship.
Check the wakalatnama.
Check, Lordship.
His name.
I will inform.
Mdas.
What more?
Give the file, writ appeal number 344 of 17. 344 17. If his wakalatnama is there, then yes. The litigant is represented. Ms. Chaudhary, now the scenario seems that I'll have to sit in a single bench and hear old matters.
Looks like.
It becomes very difficult. Because doing nothing for the whole of the day.
Apparently, my name is.
You're there, so all right.
But if the conducting counsel will inform Lordship, because it is a brief mistake, if I will inform him.
All right.
Lordship has it done.
Mr. Mdas submit that the conducting counsel in this case is Mr. S.B. Bhuyan,
AK Bhuyan.
Ek Bhuyan, and that he will inform Mr. Bhuyan regarding listing of the matter. Re-notify these appeals on, when do you want?
17th, my lord.
17th August.
Yeah, well. Deep lips.
Item number 25.
Here, my lord, we are filing the affidavit today, my lord. I have given him a copy. We are filing it in the process.
Is that matter?
Yes,
Yes. Last date, Ms. Saiki had stated
Lordship.
that you wanted an inquiry by, is this that suicide matter?
Suicide matter.
All right, tomorrow. File the affidavit today, we'll decide it
Yes,
tomorrow.
sir, we have filed it, served them copy. We'll file.
What is to be done? We'll direct CBI to investigate.
No, Lordship may see the otherwise, they.
It's a clear-cut case of murder. We'll make that observation.
Lordship may take up tomorrow or day after tomorrow, my lord.
Day after tomorrow.
Day after, Lordship.
Mr. Nath submit that the affidavit is ready and would be filed during the course of the day.
Lordship.
Re-notify on. Day after tomorrow.
Lordship.
Item number 27.
It's an appeal by the state, my lord. Where, my lord, we have come up on the ground that the petitioner had resorted to forgery while appearing before this honorable court and placing the documents which have come to light later on. And my lord, therefore, the relief granted of payment of all back wages and salary, my lord, that would not stand in the eyes of law.
That is
That would not stand in the eyes of law because
Okay.
it was a case of
based
forgery.
on fraud and fabrication.
My lord, yes.
Did you move any application for under 340?
My lord, we had filed an FIR and in our absence, there was a final report made by the police and a fake DO was presented before the learned court of the CJM and the matter, the final report was accepted. The moment it came to a notice, we made a reapplication to the court of the honorable CJM, my lord, and it was indeed proved that it was a fake
Impersonator.
impersonation, my lord. And thereafter, the matter is now being again taken up by the court, on the actions of the court. The matter is investigated by the police. That is one part of the story, my lord.
Okay.
The forensic department has said that the letters which were actually relied upon are fake. The signatures do not match of the diagraph element. What had happened is, my lord, there was at one point of time under the Provincialization Act, any person who had served for 2 years in a particular school was required to be provincialized.
Okay.
The petitioner got an order for consideration of his case. He moved a contempt petition. In the contempt petition, the orders were that it cannot be a rule of law that with 2 years you simply become provincialized. Therefore, there is no necessity to carry out that order.
Okay.
Contempt was closed. Orders were passed accordingly by the department. However, my lord, one forged letter came up which said that there is a post vacant and he should now be regularized.
Forged.
Forged.
Okay.
On the basis of that letter, there were around another 7 to 8 letters which were forged by the petitioner, the deputy secretary and the directors, time and again saying that these letters are not issued from our office. This is not our case.
Okay.
However, my lord, when he filed a repetition, one mistake had occurred, which was before the parawise comments came on the basis of verbal instructions and
the trend which was being followed at that point of time, an affidavit in opposition was filed where this ground of forgery was not taken up. Later on, my lord, when the judgment was given in favor of the petitioner, we filed a review petition. Now, in the review petition also, there was a change in the set of counsels, and this particular forgery ground was not taken up, although it was mentioned. Now, the writ petition at that point of time came up with that final report order, that the FIR has ended up in a final report, and therefore the review was dismissed. Immediately, we took up the case of the final report being submitted.
Okay.
Then all these things have come out into light. And
Okay.
therefore, my lord, we are now before this honorable court. If lordship would like to go through the records for once.
Yes.
Lordship
Can
would
you, do you have a brief, a list of dates with you?
My lord, at the top, my lord, I had given the important pages in the detail part and in
At
the.
page number, synopsis,
My lord, just below the synopsis, lordship.
because this is again, such a complicated state of affairs.
Yes, my lord.
How many, what are the,
I will place a list of dates then on the exact dates. Otherwise, my lord.
and one more thing,
My lord.
the latest status of investigation
Yes.
of that FIR.
Lordship, I'm a legal aid counsel.
Uh-huh.
It is the sole respondent.
Yes.
Here, what my brother is saying, that there was a forgery. In fact, if your lordship kindly see what my brother's placed before this honorable court,
Mhm.
will come out from a figure from page number 66, annexation number 24 of the writ appeal.
66.
66. This was an order, lordship will kindly see it was passed on 11/9/2019. And
Just hold on. Yes.
the lordship has kindly find it, lordship.
Mhm.
Now, everything started from here. Why, I will say, lordship, why everything started from here?
Mhm.
Lordship will kindly find in page number 69. The last part of the operative order, paragraph number 8, the last part. May I just read it, lordship?
Just hold on. Sixty-nine.
Yes, lordship, 69. Paragraph number 8, the last paragraph.
Appropriate forum, Mr. Mazumdar,
My lord.
appropriate forum to get an order from the appropriate forum. There are 8 of the
My lord.
order passed in contempt.
We had filed this writ appeal and the order has been stayed, my lord, passing the repetition and the review petition. That order has been stayed by this honorable court.
No, let me make the things clear, lordship.
Yes.
What has actually happened? Lordship will kindly see here at the respondent, that is the appellant, who were the respondent in that concerned writ petition.
Contempt.
That is the contempt, they were asked to deposit a check of ₹5 lakhs.
Okay.
Now from there, the entire thing started. They started digging it up. I'm not saying that this respondent is not at fault or the respondent is at fault. If he has definitely proved a false document before this honorable court, then definitely the law will take its own course. Now what has happened, Lordship, will kindly see, a suo motu contempt petition was taken up.
Suo motu contempt.
Yes, suo
Where
motu
is that?
criminal contempt petition was taken up against this respondent. And I have annexed the order of.
Contempt.
Yes,
For what purpose?
on the purpose, on the ground. Let me make it clear. In the writ appeal, Lordship, there was a delay of 483 days.
Mhm.
For condemnation of that delay, they filed an IA. In that IA, they have contended inter alia that this respondent has come up with some false document before this honorable court.
Mhm.
Court took a call on this and court took a suo motu criminal criminal contempt.
Where is that order?
Lordship, if your lordship kindly take up my affidavit, that is the affidavit in reply. I have annexed it as annexure number A, page number 8
Page number 8.
of my affidavit. Lordship. Of the affidavit filed by the respondent.
In this writ appeal.
No. In this writ appeal, I filed a reply, Lordship. For on behalf of the respondent.
Yes.
So here, Lordship.
Copy of the order dated 22/11/21.
21.
Yes.
Now there, I was also appointed as the legal aid counsel.
Mhm.
And there the honorable court found that the Tinsukia PS case number 404 of 2009 is still under investigation.
Mhm.
And if this Tinsukia case is dealing with the forgery,
Mhm.
the LS forgery. Now, if the Tinsukia case is not
complete. The investigation is still going on. So this should be a premature stage to say.
Yes,
that-
obviously, we'll need to have we'll require the status of that case, Mr. Mazumdar.
I'll have the status call.
Let us see.
I'll have the status call.
You don't have it right now.
As of right now, because I have to.
I would pray a complete report may kindly be called.
All right, Mr. Land Council, amicus curiae, Mr.
A Bhattacharya.
A. Bhattacharya submit that before proceeding to consider this writ appeal, it would be essential to direct the learned standing council that the latest and detailed status of Tinsukia PS case number 404/2009 registered with allegations of fabrication of documents against the petitioner, against the respondent, should be placed for the court's perusal. Learned Council, Mr. Mazumdar, praised for and is granted 2 weeks' time to procure the factual report list. Then, Mr. Mazumdar, if what you are saying is correct, then there should have been one more FIR for
That is
impersonation.
also being investigated in that criminal case itself, my lord. It has been taken up.
Now, Lordship,
The
just
same issue has been taken up.
adding one line. This respondent has already retired.
Hmm.
The old man of around, please,
Could not, my
Have
lord.
patience, have
there is
patience.
the facts on record, please.
Yes.
And he has already retired, Lordship, and I was instructed that he was paid salary for only 1 month. That is in 2007, and that has also been recovered. I think nothing else is left.
What about 5 lakh rupees? Have you deposited?
No,
My lord,
never.
because there
That
was-
is the stay.
my lord, there is a stay, my lord.
All right. List on, we'll list it on a shorter date.
There is no
10th August.
sequential like that. There is no-
Petition of those.
Come on, yeah.
Don't you have oral instructions? What has happened in that FIR?
My lord, actually, this matter came to my notice yesterday evening because the names are not shown as such.
Names are shown.
My
Or
lord,
Mazumdar.
my name was shown,
Then?
my name was shown, but.
Who else's name?
Because it was for the state, my lord. Yesterday evening I got it. Today I just prepared. I'll have it in. I was in touch with the police.
As a
personnel.
retired man, whatever the fate of the case be, we should decide it.
My lord, the
We should
initial.
not keep on hanging like
Yes,
this.
I'll have it.
Okay, 10th August.
Item number 28.
Yes.
My lords, in this matter, we have given an NOC to the petition, to the respondent, and he is in the process of engaging another advocate, my lord.
Then Council, Mr. Your good name, please.
A Borua, my lord.
A. Burua submit that the respondent has withdrawn instructions for instructions from him and would be engaging another counsel to appear in this writ appeal.
My lord, may I pray that the names of the respondent advocates may be struck off.
Name of Mr.
KP Pathak and S. Banik.
K.B. Patak and Mr. S. Banik shall henceforth not be displayed as counsel for the respondents in this writ appeal. Respondents kar dijiyega.
I'm obliged.
Re-notify on. We make it clear that in case no counsel appears on behalf of the respondents on the next date of listing, we will proceed with the consideration of this appeal ex parte. Re-notify on 9th August. 9th is okay. What is the matter, madam?
Lordship, this is regarding the payment of compensation regarding the land near the Raj Bhavan, Your Lordship.
Near the
Governor House. Raj
governor house. Okay.
Obliged.
Bhavan.
Item number 30.
May I please, madam? Here we are excelling the orders passed by the learned single judge, my lord, where my challenge to the denial of promotion was, my lord, rejected.
Promotion.
Promotion. My lord, what had happened is, I was given a minor punishment in the year 2008.
Mhm.
My lord, in the year 2011, I qualified the senior cadre course. In the year 2009, it is a stand of the respondents that it was converted, it was reclassified as a major punishment. The punishment was 1 year.
One grade increment without cumulative effect.
Without cumulative
That is a minor
That is a
punishment.
minor punishment. Now, when I was supposed to be considered in the year 2012 for promotions,
Mm.
in their affidavit, they have admitted I fulfill everything else. I was totally eligible. I was senior enough. I was everything. But only because it is now called classified as a major punishment
Classified in the rules.
in their establishment manual. which was modified after my punishment had been given. Even the punishment order says, taking a lenient view, I am giving you this punishment. So it was for all
So
intentions.
that
it was always minor.
reclassification is after the punishment was imposed. Let us see how the single judge has dealt with this aspect.
Well, that it was taken after the punishment had been imposed, that aspect was not at all.
Whether it was argued.
Yes, madam.
Let's see.
Yes.
Let's see the grounds of writ petition. Grounds in your writ.
That the modification had come was only during the writ petition. In the affidavit in opposition, we came to know that it was later classified as a major.
So did you raise an additional ground?
Yes, my lord. It
Let's
was
see.
there. It was there, Lordship will find in the affidavit in reply also.
Now this argument is there, clause
Yes, argument is
at
there.
page 4 of the judgment.
It was argued, my lord. It was argued, and if Lordship will have page 47, page. It was dealt with. Yes, at page 88, Lordship will find para 19. When a single judge has dealt with this. The said establishment manual till 3156, it is wrongly printed. It is 13/5/2009. Categorize stoppage of grade increment as minor punishment under clause so and so. However, by way of an addendum to the establishment manual dated 13/5/2009, categorize the stoppage of increment as major punishment. So this was noticed that the addendum came on 13/5/2009. My punishment was in the year 2008.
4/3/2008.
4/3/2008, that Lordship would find has also been taken note of by the learned single judge.
What do you say, Mr. Parashar?
Yes, earlier he was dismissed for service and
That was substituted by the appellate authority for the minor punishment of stoppage of grade increment without cumulative effect.
Yes.
So that is a settled criminal jurisprudence, service jurisprudence, that stoppage of grade increment without cumulative effect is a minor penalty. You have brought it out in your establishment manual as a major penalty. That is a different matter. But then again, what is the date of your instruction?
The date of the order is 4/3/2008.
Obviously.
But
So
regarding the consideration of the his promotion is
but
4/9/2008.
the nature of his punishment has to relate back to the instructions which are prevailing on that day. How can it be made more onerous by a subsequently introduced establishment manual instruction? That too is an administrative instruction.
Yes.
So that can never have a retrospective effect.
But as per section 18 provide us to make some rule of the act.
Where is your instruction? Does it read that it will have a retrospective effect? It may have a devastating effect on so many other employees then.
No, not specific.
Then
not specific.
that effect has to be considered on the date of the imposition of the penalty. Maybe that he is getting the gain or the advantage on a subsequent date, but the instruction as it prevailed on the date of imposition of penalty, that has to hold the field.
Yes, only on the date of consideration that is there, but
Consideration, the nature of penalty can't be changed retrospectively. No?
yes.
Let's see how this argument has been dealt with. Have you got any judgment on this aspect, Mr. Mazumdar?
I have got a judgment to say that it is a minor punishment for the Supreme Court. Anything without a cumulative effect will be considered.
That is all right, but then their executive instruction, they can very well classify what is the nature of the punishment. Can they do it or not? Then if you cite that judgment on the proposition that in any situation, inescapably, the penalty of stoppage of grade increment is a minor punishment. Supreme Court must have said it in reference to the certain set of administrative rules or instructions.
Yes.
But herein there is a specific executive instruction. The larger issue in this case is whether the executive instruction would be operable in reference to the date of punishment or in reference to the date of consideration.
Date of consideration.
That I can get immediately.
Get that judgment. We'll pass it
It
over.
has to be prospective unless it is stated to be.
Yes, let us see that. Let us see. A perspective also would not matter in this case because the application of the executive instruction is being made on the date of consideration. So that is what the thing is. Whether the nature of punishment can be changed retrospectively by that executive instruction. That is what the argument has to
We'll
be.
have it on Wednesday then.
All right, Wednesday. Thursday rather, not
Thursday.
Wednesday. Problem. Third August.
Item number 31.
This matter has been transferred here.
Hmm.
I think, my lord, we have not a very good case for the state. But because your lordship knows, a rule has been made by a state, 2013, Mizoram Engineering Service Rule. But they brought a notification in 2021. Learned single just says, is a vacancy based or is a post based? Now they initially rule says, my lord, it is on the basis of the seniority. Now we made a memorandum in 2021 saying a post based on the based on a judgment of the Supreme Court, that is R.K. Sabharwal. That's the law is correct, my lord. But what about the rule, my lord? We made a rule in 2013.
Mr. Das, problem here is that there are counsel representing the respondent.
I know, that's why I have not seen them.
They are not visible on VC.
Yes, I think we
Inform kiya kya? Whether we have informed the advocates. The matter, this writ appeal, which normally should have been heard at Aizawl, has been transferred because both honorable judges at Aizawl are not in a position to hear the matter. Stationed at Aizawl are not in a position to hear the writ appeal. The respondent was represented by learned counsel, so and so. Thus, these learned counsel have to be informed of the fact that this appeal has been transferred to the principal seat at Guwahati, and that is there anyone appearing?
Somebody appeared.
Did anyone appear in the appeal? No, we don't find. Always the government counsel appear.
Yes.
Yes, Joseph Lalchinmia.
Yeah.
Lalchanmia. Lalchanima.
For the respondent.
Yes.
Yes,
Mr. Counsel, Mr. Joseph so-and-so has already put in appearance on behalf of the respondent at Aizawl. Thus, the counsel representing the respondent shall be informed about the transfer of this appeal to Guwahati. He may also be informed that he would be at liberty to address the court through VC if so desired. List name of learned counsel, Mr. So-and-so shall henceforth be reflected in the cause list. Re-notify on 17th August. 17th August.
Possible matter 17 to 19.
It's that matter, my lord, wherein that teacher's pay in the LP school was fixed by the recommended by the pay commission. Government accepted it. And thereafter they notified 8,700 for my lord graduate teachers and 6,200 for undertrained teachers. Subsequently, the government on their own, my lord, constitutes an anomaly committee. Anomaly committee is for me to go, but they put it before the anomaly committee. Now, anomaly committee says you are not entitled to 8,700, you are entitled to 7,400. Whereas untrained teachers, my lord, who were getting 6,200, and in LP school, they were also getting 6,800.
Yes.
ME school, they were getting 6,800. 6,200 in LP school has been made 6,800.
Okay.
Whereas we have been brought down. My lord, we'll have it on a other day, but unfortunately.
None present for the respondents. Matters were followed. None present for the respondents. re-notify on 22nd. 2006.
Contempt.
Now we are trying to dig out matters and list them for hearing. There's nothing.
Contempt. It will resolve.
It's a very painful thing for us to get up and do nothing for a whole of. Citing the writ petition, we may observe that yes, since they have not challenged, their cases may go as per that. But when we have made an observation in our order that the very legality of your exercise of cancelling the selections made is under question, under a question mark, how can we allow you to proceed with the fresh selection?
Prima facie, my lord, since
So we can simply say, we'll request the writ court to expedite the writ petition.
the problem is, my lord, I'm not,
Will the commission be able to function without these two people? No. So what is the fun of it?
it can, my lord. So far as, if we have a chairman and a member.
So we can say that you may proceed with the selection, but you will not make appointments. That we can clarify them.
And
So what are the use?
And simultaneously, if your lordship also makes a request to the learned single judge.
First, Mr. Chaudhary, it is better that you request the learned, we'll request the learned single judge to expedite the decision of the writ petition.
And simultaneously, we may be allowed to proceed with the chairman and one member. We are keeping these two posts vacant.
No, we'll not allow you to fill in the post because that process,
We'll proceed finalized.
the result will be kept in a sealed cover, will not be declared. What else?
And
What do you say,
simultaneously.
Mr. Patwari?
As long we are protected.
They are concerned
You are
about their-
otherwise also protected. Madam, what do you say, madam? We'll just say that they may proceed with the selection of the chairman and the other member, and but the result will not be declared.
And simultaneously, well, that request to the
Yes.
learned single judgment.
This is an
Otherwise, one of the-
application seeking clarification of the order dated 9/6/23 passed by this court in writ appeal number so and so. Then counsel, Learned Advocate General, Mr. Chaudhary submits that since the one member and the chairman who were simultaneously selected along with the respondent herein in the process for selection of chairman and members of the Arunachal Pradesh Public Service Commission, they have not questioned the decision cancelling their selection, the state may be permitted to undertake a fresh exercise for selection of the
Not a fresh one, a continuation of that advertisement which has been put to challenge. That advertisement itself was for one chairman and three members. What we are saying is, we may be allowed to proceed with the advertisement so far as the chairman and the other members.
the state may be allowed to proceed with the advertisement dated
It is 28/4/23.
28/4/2023, whereby, fresh selection was initiated for filling up these posts.
Of one chairman and three members.
Posts of one chairman and three members of the commission. Mr. Patwari, representing the respondents
In writ appeal
in writ appeal so and so,
205.
there are two writ appeals now,
And my friend appears in the other writ appeal.
and Mr. So and so appearing for the respondent in so and so. Submit that as long as their client's interests are protected, they do not have any objection to the selection process being carried forward. In view of the facts and circumstances noted above, we hereby permit the state to proceed with the selection process as a consequence of the advertisement dated 28/4/2023 for the posts of chairperson and one member of the APPSC. However, in view of the fact that the very legality of the decision to cancel the earlier selection process is pending, is under challenge in the pending writ petitions number so and so, comma, the result of the fresh selection process shall not be declared till disposal of the aforesaid two writ petitions. We further request the learned single bench to expedite the decision of the writ petitions. Deadlock reapplications are disposed of accordingly.